Questions from our viewers. Hi everyone, I'm immigration attorney Andres Mejed. In this video, I'm going to answer some questions from our comments on our Facebook and our YouTube channels. If you have a question you want answered that isn't covered here, comment below. We'll try to get to it in another video. Let me first introduce myself for those who don't know me. I'm an immigration attorney and an immigrant. I came to the US as a child and obtained my citizenship as a young adult. I know what my clients are going through on a personal level, not just as their attorney, and my goal is to make that process as quick and as stress-free as possible for you. I want to remind everyone that we have a new president taking office in January. If you are somehow unaware of this fact, there are over 400 changes that Trump has made to US immigration while he was in office. So President Biden will have a lot of work to do to fix it. However, we anticipate that things will be smoother and easier for many applicants. Because of that, we are encouraging all of our clients and you, the listener, to make sure that you are at the head of the line. That means getting your application in ASAP so you have your priority number secured. And very briefly, almost every day, the Trump administration announces new immigration policies they are putting in place. A few just this past week include they're going to take away birthright citizenship or make immigrants traveling from African countries pay a large bond to enter the US. Try not to panic. Many of these suggested changes are illegal. As we have seen, this administration has no problem ignoring the law. But as has been true during these past 4 years, if they do try to ram their policies through, there will be lawsuits filed by, and most likely policies will be stopped while the lawsuits are processed, if not completely ended. First question we have from a viewer is from Carmen. Carmen, thank you for your question. Carmen said that her son arrived on Saturday and applied for asylum, and now she wonders how he can go back to his country. Let's talk about asylum. You can apply for asylum when you are in the US or outside the US. However, those who apply outside the US are called refugees, and they usually apply through some non-governmental entity, an NGO. When you apply for asylum, you are saying to USCIS, to the US government, that you fear if you stay in your country or return to it, you're afraid to go back because you're going to be hurt and or killed for a protected reason, like religion or political opinion. I talked about this more fully in a video that I'll link to below. If you then go back to your country, it looks like you're really not afraid to go back there. After you apply for asylum, you can travel outside the US with the proper documents, not your passport, but travel documents. But you cannot return to your country without jeopardizing your status until after you become a US citizen. If you do travel to your home country before you become a US citizen, you could be refused re-entry by DHS, and even more serious, lose your asylum status. The way the asylum process works is you apply for asylum. Once that is granted, you then a year later can apply for a green card. After meeting a time requirement of being a green card holder, 5 years when you obtain it through asylum, you can then apply to become a US citizen. And then and only then would I say that it is somewhat safe to travel to your home country. However, keep in mind, when you apply for immigration benefit, you promise that everything you are saying is true and correct. So if you promise that you are afraid for your safety, and that is not true, you could lose any immigration benefit you received, including your citizenship. I highly recommend that you talk to an immigration attorney to determine the best way to achieve your goals so that nothing you do hurts your status or your ability to get status. Let me answer a similar question from someone else. This viewer's husband was applying to remove the conditions from his green card. He was waiting for the interview with USCIS. While waiting, he traveled to his home country. His conditional green card expired while he was out of the country, and now he wonders how he can get back into the US. I've had several videos recently where I talk about traveling, and I'll link those below. Frankly, he may have to start the entire process again. His spouse said that they didn't understand that the green card he received was conditional. If you look at your green card, even if it's permanent, it has an expiration date, unless it's from the 70s or the 80s or earlier. You should be sure to check this date prior to traveling. As I mentioned in my other videos, if you travel outside of the US while having a conditional green card without travel documents that authorize you to come back, it can be viewed by USCIS and DHS that you abandoned your green card application. So now, he might need to start the entire process over, even paying the fees again, and most likely do it from his home country. First, I would ask, how long were they outside of the US? If his green card expired yesterday and he was outside the US for a short time, he likely won't have a problem, but he needs to go to the nearest US consulate or embassy. However, if he was outside the US for a year or more, it is likely that they will have considered that he abandoned his green card. Now, there are two exceptions. One, re-entry permit. If it was approved for re-entry permit before he left the US, he can stay outside the US for up to 2 years. As long as the re-entry permit is valid, he can return to the US. 7. Returning resident visa. If his stay outside of the US was due to extraordinary circumstances outside his control, like COVID, he'll be able to come back. Now, he's going to need to show, 1, he was a green card holder when he left. 2, he never intended to abandon his residency. And 3, his stay outside of the US was caused by reasons outside of his control, like COVID. I'm not trying to make them feel bad, but if you have a conditional green card and you want to travel, talk to an immigration attorney about the way to do so without losing your status. It's really a good idea. Anthony had a question about traveling and how it might impact his biometric appointment. Anthony said, what would happen if I go on vacation and months go by before my fingerprint appointment is due? Can I have a problem? There are two issues here. I'm not entirely certain which one is true for Anthony, so I'm going to talk about both. First, I'm not sure what immigration benefit Anthony has applied for. So to answer this, we're going to presume it's a green card through marriage. Anthony wants to know if he can go on vacation before getting his fingerprints done. Anthony, you can travel anywhere in the US before getting your fingerprints done. If you are planning on traveling outside of the US, I would not recommend you do that if you are applying for a green card or working to remove conditions without first obtaining advance parole. That's a travel permit. Now, that allows you to leave and come back into the United States without abandoning your status or your application. Now, let's talk about another scenario. Anthony has an appointment to get his biometrics done. If you don't know, at your biometrics appointment, you have your fingerprints taken and provide other identifying information so that USCIS can run a background check. They take your photo, they look at your eye. Anthony goes on vacation and misses his biometrics appointment. How does that impact his immigration journey? If you miss your biometrics appointment, and it was not long ago, say within a week or so, you can ask USCIS to reschedule the appointment by checking a box on the notice. USCIS will usually reschedule this, but keep in mind, if you do this, you may have to wait for a new appointment for several weeks, 2 months, which could slow down the processing of your case. You could also try to go to the center where your appointment was scheduled. With your notice, explain the situation and ask them to reschedule or process you right then and there. They don't have to agree to process you, but they may. As the saying goes, if you don't ask, the answer is always no. So I recommend at least asking. If your appointment was a long time ago and you missed it, you should check to see if your case is still open. Google USCIS case status, put your receipt number, and you'll have your information. If it is, you should call USCIS and ask if they will schedule a new appointment for you. What about if you're outside of the US and you miss the appointment that's scheduled inside the US? If you are outside of the US and you miss your appointment inside the US, we recommend you contact your local consulate, your local US consulate or embassy to see how they can help you. USCIS field offices, that means those not in the US, are not likely to provide the services, but they do in very rare instances. Cami said she won her case for removal proceedings, and now she wants to know how long before she gets her green card or what the next step is. First, congrats, Cami. That must be a huge relief. When you say win the case for removal proceedings, there's a few scenarios we are looking at. Since the most common is obtaining a cancellation or removal through EOIR, Executive Officer Immigration Review, that is the one that we will discuss today. At your final hearing, the immigration judge announced that he or she intended to approve your application. However, there are only 4,000 visas issued each year. If a visa was available for you, that's great news. If there wasn't a visa available, you will have to wait until you receive the judge's order approving you. It could take 1 or 2 years. This order should say that it approves the cancellation, removal, and adjustment of status. It will say that you are being granted relief under Form EOIR 42B. At the hearing or in the notice, the government attorney should give you instructions on how to make an InfoPass appointment with USCIS, which is necessary to get your green card. Since EOIR and USCIS are two different immigration agencies, you need to let USCIS know that EOIR said you are eligible for a green card. USCIS should get a copy of the file from EOIR with the order stating you have been granted the cancellation or removal. When you go to your InfoPass appointment with USCIS, bring the original EOIR order, the immigration judge's order. Keep an original copy for yourself, as well as bring copies with you. They will need to verify your identity, so bring a valid government ID, such as a driver's license or passport. If your biometrics are not current, you will probably need an appointment for that as well. They may collect your fingerprints at this appointment, or they may make you schedule another one. After your InfoPass appointment, USCIS should order your green card for you, and you will receive it in the mail, usually within a few weeks, but with COVID and USCIS slowdowns, it may take longer than that. Make sure that if you are eligible for employment authorization, you file for that ASAP. If the judge doesn't finalize your order at your hearing, you must wait 30 days for that to happen. During that time, the government could appeal the decision. If they don't and your order becomes final, you will need to follow the same steps we just discussed after you receive your final order. Even if the government appeals the decision, you may still be eligible for employment authorization, so be sure to follow the steps outlined in the USCIS website to get that. Next question. Belem talked about a sad situation. Belem said that she got married in Mexico 20 years ago. She said she and her husband had several daughters, and then he left them and she had to raise them herself. He moved to the US and later became a US citizen. She wondered if she could obtain citizenship. I'm presuming that since Belem said her husband abandoned them, that she is not in contact with him. Unfortunately, when you apply for an immigration benefit through marriage, you must have a spouse who sponsors you. Remember, you must prove that you have a bona fide marriage in order to get a green card through marriage. If they are not in touch, then he obviously could not apply for her. He could, however, apply for his kids, the kids they have together. Belem, you may qualify for a green card through a U visa or VAWA. If you want to find out if you meet those requirements for either of these, talk to a qualified immigration attorney who can help you with the process. We have videos explaining the process and requirements for both U visa and VAWA. See below for links to those videos. Likely VAWA may give you an option, U visa probably not. Laura had a similar question. She was deported 20 years ago. She had a son who is abusive and a US citizen. She wonders if she can apply for VAWA. I do have a video about VAWA and the requirements you must meet to apply, which I'll link below. If Laura was deported, that probably means she today is living outside of the US. There are a few conditions that allow you to apply for VAWA when you are outside of the US. If you and your abuser were living outside of the US when you were the victim of abuse and they worked for the US government. You and your abuser were living outside of the US when you were the victim and he or she was in the military. Or you are living outside of the US but were a victim while living in the US with your abuser. You must also meet some other requirements, one of which is that you lived with your US citizen child or sponsor at some point. So Laura, if they are in the US and you are not, you may not be eligible. An immigration attorney experienced in VAWA should be able to confirm after reviewing your individual circumstances. VAWA is one of the specialties of our office, so we are happy to chat with you about your situation and figure out if you are eligible and if we can help. I want to remind everyone that even if you have been deported, you may be able to have that waived and show you're admissible. For example, when you apply for VAWA, VAWA includes a waiver. Please consult with an attorney to help make sure this is handled correctly. We had a few questions about the military, so I thought I would answer those now. E. Marcos Mario asked if it would be easier to get a visa or a green card if he wanted to join the US Army or Air Force. Thank you for your question, E. Marcos. There are a couple of parts to this question, so let's break it down. Which is easier to get, a visa or a green card? A visa is usually a non-immigrant visa, which you get in order to visit the US. With that, you are promising that you do not intend to stay in the United States permanently. If you are wanting to stay in the US permanently, I don't recommend that you apply for a visa, or that could lead to problems with your future immigration goals. Again, this is general advice. Yes, a visitor visa is often easier and faster to obtain than a green card. However, a visitor visa won't let you join the US military. In order to join any branch of the US military, you must have a green card. In addition, you must be living in the US when you apply. The military states that they cannot or will not assist you to get your green card. A few other things to keep in mind. Just because you got your green card, there are still eligibility requirements to join the military. They usually won't allow anyone who was a citizen of a country that was hostile to the US. Think Russia, North Korea, Cuba, China, and others. Also, until you become a US citizen, you may not be eligible for certain security clearances that are required to do many jobs in the military. The DoD, Department of Defense, will not grant security clearance to non-citizens. So whatever you plan to do in the military cannot require you a high security clearance. We also had a question from ZG about the military. ZG said that their son was in the military and wondered if you could sponsor his grandmother. Thank you for your question, ZG, and to your son for his service to our country. When you're in the military, you're only allowed to sponsor immediate family members. Immediate family members include, this is true for all immigration matters, spouse, parents, siblings, and children. So unfortunately, ZG, a grandmother would not be an immediate family member, and your son could never sponsor her. However, if you yourself have legal status, such as a green card or citizenship, you may be able to sponsor her. So if your son applies for you, once you become a lawful permanent resident or a US citizen, you could then file for your mother. So your son can't directly file for the grandmother, but can file for you and you can file for her. That's all the questions we are covering today. We hope that you found this video helpful. As a reminder, these are public channels, so please don't post private information here, but do contact us if you have questions specific to your situation. Like and subscribe to our channel to find out when updates happen. Thank you and be well.